Good afternoon, everybody. My name is Karen Starbowski. I'm with Mass Mutual Arizona Special Care Planning Team. I'm here with Megan Selvey from Bivens and Associates today, and we're going to talk about life care planning and guardianship. So today I am going to go first. So I'm going to share my screen and bring up my presentation. So give me a moment to get started. It's always the technical stuff that you have fun with, folks. Megan, can you see the correct part of the presentation?
I can, yep.
Okay, thank you. I can't see myself, which is weird, but that's okay. So again, welcome. I appreciate you guys taking time out of your day to be here. I just wish I could see myself. Okay, oops. Appreciate you taking time to be here. I know everybody's schedules are a little wacky right now. We're going to talk about, like I said, finding life care planning and guardianship today. This first slide is my disclosure slide. If I could talk, not mush brain, we'll be all set. This slide says that I am not an attorney, nor am I a CPA, so I can't give you specific tax or legal advice. And I also want to disclose that Megan is an employee of Bivens and Associates, not Mass Mutual. So I have to get that out there. So what's important to you as a caregiver? This is what we're thinking about when we're creating a life care plan. And we want to take into consideration what will happen to my dependent after I'm gone. What plans will be in place when you are no longer here? So some of the big things that we want to talk about is medical treatments, education, all these things on this list. You know, if something should happen tomorrow or when you're 102, all these things are still going to be taken into play. Very important thing, if your kiddo's between ages 16 and 18, education. Will your kiddos stay in school until they're 22? If not, what are the plans? Do they need more job skill training? Do they need more life skill training? Are they going to go to college or tech school? So it's important to lay out that plan. You don't want to have your kiddo getting out of school and not having a plan. You know, it's hard enough to get them off the couch if you do have a plan. So you want to make sure that's in play. Are they capable of having a job? And what type of job? Do they need more job skill training? So that's where the employment thing and the skill development falls into play. Very important parts of your plan. Kiddos, just like adults, continue to develop, and we want to continue to educate them in different ways. Housing. Housing is a very stressful thing for parents. You know, where will your kiddo live? Every plan is, designed specifically for each family. Some families will say, okay, by the time my kiddo's 28, we're going to move him or her out. Some will say, well, they'll live with me for as long as they can. Either way is fine, as long as you have a plan in place. The other thing that I always recommend is kind of get an idea of what is out there. Start touring different places, taking tours, see what might be a good fit for your child, so that should something happen to you tomorrow, somebody else isn't scrambling trying to figure out what's the best fit for your kiddo. Transportation and travel. Is your child capable of driving? Many are, so we want to make sure, people know that, or that your child gets the training to do that. Does your child take public transportation? Are they able to get around the city on their own? These are all important notes to have in your plan. And I think the last bullet is one of the most important and most forgotten: social and recreational. We think of all the financial things, we think of the legal things, the medical things. We don't think about the social and recreational. What can round out your child's life. What do they like to do? Who do they like to hang with? What activities, what organizations? Really super important to have in your plan. Reviewing beneficiaries. Now, Megan and I push this a lot because it's probably one of the most common places to screw up, to put it bluntly. Most of you are probably aware that your child cannot have more than $2,000 in assets because it'll knock them off their government benefits. So we don't want you to pass away and have money flow to your child and then things need to be fixed. Also one of the key points here that people forget is your 401k plans, because many times HR person brings you the form, you put in your spouse, that's the end of story, you go back to work. The problem with that is if you and your spouse are in the car together and heaven forbid something happens and you guys both go at the same time, the 401k is going to go to your next of kin, and that's going to be your children. And if one of your children is a child with special needs, it's going to throw them off benefits and Megan's going to have to fix it. So we don't want to do that if we don't have to. I want to pause right here because I forgot to mention something at the very beginning. We will be taking questions throughout this. So if you have a question, feel free to just hit the raise your hand button, and Megan will let me know that you have a question. Back to beneficiaries, there's also, relatives. So we want to make sure beneficiaries are correct and don't screw things up in the future. Holding a family meeting. I think this gets forgotten a lot. When you have a child with special needs, you have a lot of things to focus on. You don't always remember that there's other people in your life that may be wondering, if something happens to me or something happens to my sister, what's going to happen with her child? So we want to make sure this is communicated so people understand. If you have typical children in your family that are older, they may be wondering, hey, if something happens to my folks, who's going to help me take care of my brother? This is not a place where we're going to say, you have so much money. That's not the point. The point of this meeting is to discuss what the plan is, who will take care of your child if you're not here, where he or she will live, what sort of activities they will be involved in. All of those things would be revealed. Super, super important. So create a team. We want to create a team of people that know the special needs community. I am a chartered special needs consultant, which means I have letters after my name that I've gone to school to understand planning for families with family of kids with special needs. It's important. The special needs community is complicated. It has a lot of rules and regulations, as I'm sure you are all aware. So you want to choose your professionals that know this community and know the rules and the regulations. Same with a special needs attorney. Megan is very involved with the special needs community. She does a lot of special needs trusts. But choosing your attorney is super important, that they work in this community. Any attorney can write a special needs trust. It doesn't mean they know how or they know all the exact language that needs to go into your document. I always tell people, if I see a mistake as a non-attorney, you're in deep doo-doo. We also want to, your accountant. There are a lot of credits, a lot of different things in when you do your taxes that many people aren't aware of, they're not using to their advantage. So choosing that professional wisely is important. And then rounding out your team with your healthcare professionals, a counselor, a social worker, a spiritual advisor. This is having a child with special needs is challenging. And we want to make sure everybody is a part of your team, knows what's going on, and can help you with guidance as you're planning. So where can you get additional support? We are very fortunate in Arizona. Now, it might not always seem that way because I know, getting different benefits and getting things in place can be a challenge. But we have a lot more resources here in the greater Phoenix area than many, many other cities around the country. So we are very fortunate. We have quite a few nonprofits in the area who can help families and help you get things put in place, whether it's job skills or life skill trainings or help with IEPs. We have a lot of resources in the Valley. And remember, many parents have gone through this before you, so don't try to recreate the wheel. Super important, ask for help. Many of these organizations have newsletters that go out monthly, some go out weekly, to tell you about activities that are going on, provide information, educational information to you. We also have a lot of support groups in the Valley, and they are for parents, they are for kids, and they are for siblings. So, keep that in mind. Again, you don't want to be alone on an island. Get help and guidance and support wherever you can. And we all know there's government agencies and, we need their benefits and we need their assistance, but they can be challenging. So, use me as a resource if you need assistance. Don't be afraid to call or send an email. I never pretend to know everything, but I do know a lot of people that know stuff, so I can always point you in the right direction. This is a scary, busy slide. And government benefits is an hour presentation all on its own that Megan has helped me with many times. So I'm just going to hit on some highlights on this slide. There are benefits that you are entitled to, and there are benefits that are public assistance that you need to qualify for. So on the public assistance side, I'm sure many of you are familiar with SSI, or Supplemental Security Income. This is, if your child is qualified as disabled, they would get the $783 a month. The kicker for that is if your child is under 18, they look at your resources. And if you have more than $2,000 to your name, your child will not get the $783 a month. They would still qualify for Medicare, but they would not receive the SSI. Now, when they turn 18, they will requalify on their own. And if they do not have the $2,000 to their name, they will get the $783 a month, or however much that amount is when your child turns 18. It's a huge benefit, and some people may say, well, it's not a ton of money, and I always say, well, it's not a stick in the eye. And I also say it comes with another benefit. Oh, I'm jumping ahead of myself. The SSI will provide a future benefit that you will like. So when you start taking Social Security at your retirement age, so say it's 67, you start collecting Social Security, your child has been on SSI for 10, 15 years, your child will get a raise based on the fact that you're going to start taking your Social Security. They will get up to 50% of your Social Security benefit. This does not affect your benefit at all. It just increases theirs. Now, this is where the added benefit comes in. Once they've been on that increase, we call it children's benefit or disabled adult child benefit. They get that increase at your retirement. After 2 years of being on that benefit, they would qualify for Medicare. So that's a super huge benefit to have in their pocket. And then when you pass away, they'll get another raise, and that'll be up to 75% of your Social Security. Again, that doesn't interfere with your Social Security. It's an additional benefit. Some other benefits that your adult children could apply for is SNAP, which is the old food stamps program. That is a program that you have to qualify for. The one that's not on here that some of my clients use is the Section 8 housing, because their kids live independently in apartments, maybe with other adults with special needs, and that's a huge benefit. Another slide that can be a whole presentation on its own, and Megan and I have both given it. I'm just going to touch on a few points here. Letter of intent, not a legal document, but super important to have in your plan. It captures all the minutia about your child. So anything from medications, doctors, allergies, triggers, to favorite people, to favorite things they like to do. So it's that document that somebody could pick up. If something should happen to you, they could pick up this document and not have to start from scratch. I've even had spouses say, we need to do that because if something happens to you, I need to know where to start. So very, very important. Excuse me. Megan's going to start or talk about guardianship and conservatorship, so I'm not going to touch on that. Wills are great, and she'll probably touch on that because you can capture guardianship in them. But they do go through probate, and if not properly designed, they could give your kiddo more than $2,000. Well, talk about putting your phone on mute, Megan. I guess I forgot. So we, put a special needs trust in place to protect your child from receiving $2,000 upon your passing. Special needs trust specifically. So many people will come to me and say, I don't have that much money. Why do I need a special needs trust? Well, if you have more than $2,000, it's important that your child doesn't inherit that and throw them off their benefits. I have other families that'll say, well, I have an older daughter. I'm just going to leave all the money to her. Well, Megan and I have both heard horror stories about other children inheriting. You might have the best intention, but life happens. So what happens if your older daughter gets married and gets divorced? That money then goes to her ex-husband. What happens if your older daughter has to file bankruptcy? There goes all the money that you left her. What happens if your daughter gets in a car accident and gets sued? There goes all the money. So special needs trusts are important because they protect your child's government benefits, and they allow you to leave directions on how you want your child to be taken care of, how you want these assets to be used for your child. So super important. I am not going to touch this slide because Megan's going to talk about it and she'll say more detailed things than I ever could. This is a toughie. So I mentioned earlier that, housing is really challenging for parents, just the thought of where is my child going to live. The other stressful point is I need to find a care provider. And parents will say, I know best, I can care for my child best, which in most cases is probably true. The problem with that is you're not going to be here forever. So who is going to care for your child? So this is part of, what we can help you with. Will it be a family member or a friend? Could it be an organization? It's a very important point in your plan to put this in place because you want to be able to figure this out. You don't want others to have to figure it out for your child. Again, I guess the letter intent is so important. We're going to put it in the presentation twice. So like I mentioned, very important because it captures all the minutia about your child. We recommend doing it in a Word document. We have a template. So that way you can update it every year because life changes, your child grows, things change. You want to make sure it's totally up to date. I mentioned the Word document. I am seeing people also use video. I think that's a good combo, but doing the whole thing in video I think could be cumbersome because you're repeating the entire process year after year instead of just updating it. But it's a good, if your child has behavioral issues or speech impediment, it's a great way to help people understand how to assist with your child. So how do I start? Starting is probably the hardest step for most parents. Just getting started. Not even more than that, just getting started is probably the most challenging thing. But, you know, finding, like I mentioned, finding those professionals that will help you work with your child and create a plan, finding those professionals that know the special needs community and know all the rules and regulations. We always want to think about, you know, creating a plan for when you're 102 and you pass away, but heaven forbid, what happens if something should happen tomorrow? We want to make sure that somebody else isn't having to start from scratch and figure things out. Uh-oh. Sorry, guys. There we go. So how can I help? I've been working in the special needs community for over 10 years. I've created a lot of relationships. Bivens and Associates with Megan is one of those relationships. But I can help introduce you to other nonprofits, help you create a network for your family. Also, you know, introduce you to different ways to fund your special needs trust. You know, that's not a simple thing either. And again, every family is different on how they create their plan and how they fund their plan. So I want to be there to assist you. Like I said, I've been working in the special needs community for over 10 years. I enjoy helping families create plans for their children. And as part of this presentation, if you give me a call and say you were on the August 26th webinar, I give you a 30-minute free consultation to see if I can help you out. That being said, I'm gonna unshare my screen so that Megan can get started. And don't forget, if you do have any questions, feel free to raise your hand and we will answer them as we're going along.
Hey, Karen.
Yes.
I am not sure if I missed someone with a question because while you were sharing your screen, I can see a list of the participants, but I can't see their screens.
Okay. So again, if anybody has a question, go ahead and raise your hand and we'll take them. And if not, we'll get started with Megan and I'll try and keep an eye on it. If we miss you, please hang around at the end and we'll make sure we answer any questions you may have. Go ahead, my dear.
Okay, so you can see my slideshow, right?
Yes, I can.
All right. So I'm going to talk to you guys about guardianship and conservatorship. So
switch your display, please.
Why?
I see both your screens, both your slides. Your display, do you have two monitors?
I do.
So on the top it says display settings?
Yes.
Perfecto.
Okay. Thank you. Look, thank you for tech guidance from Karen Starvowski. Wonderful. All right, so guardianship and conservatorship. In Arizona, so every single state has their own state laws and state rules that apply to guardianship. So let me just start with guardianship in Arizona is appropriate for somebody who lives in Arizona. So if your child lives in another state permanently, if you're moving very soon to another state permanently, you know, you want to talk to somebody in that state. So for those of you who are in Arizona, your child's going to remain in Arizona. This is the place. What guardianship is taking over legal decision-making of an adult. So in every state in America, when someone turns age 18, in the eyes of the law, they are an adult. It doesn't matter what kind of medical issues they have going on. It doesn't matter if they've had diagnoses since birth. You know, in the eyes of the law, you're a competent adult at age 18 until the court determines otherwise. So that's what guardianship is. It's the court making a determination that this is a person that does not have the ability to make appropriate legal decisions for themselves regarding their health and well-being. At the end of this, I'm going to talk about conservatorship. Conservatorship in Arizona deals with money. Guardianship is what we talk about when we're talking about someone making like healthcare decisions, education decisions, where someone lives. So I'm going to talk about it as like health and well-being is the way that I refer to it. Conservatorship is money. Other states are different. Other states have different terminology, but those are the terms we're working with. All right, there's a couple different types of guardianship that you can have. You can have a temporary or an emergency guardianship. This might come about if, in a few slides, I'm going to walk you through, there's a procedure with the courts to, have a guardianship be properly done. Sometimes we don't have time to go through all those steps with the court because sometimes, life happens and somebody really needs an emergency decision maker right away. So in very limited circumstances, we can kind of skip the line with the court and get a court to implement a guardianship, but those are rare circumstances. Most of you are going to wind up with one of the three of these: a full guardianship, a limited guardianship, or guardianship with inpatient mental health authority. So let me just describe briefly the difference between a full guardianship and a limited. In Arizona, under Arizona law, you can limit the guardianship through one of two ways. One way is that the person who needs the guardianship is going to retain their driving rights, their ability to obtain a license through the DMV and drive. And the other way is they're going to retain their voting rights. A full guardianship is when someone loses their right to drive and their right to vote. And of course, the guardian has all the other powers in order to consent to healthcare treatment, living arrangements, etc. But some people who are, where a guardian is still appropriate, where someone is not able to really make big life decisions for themselves, but they're competent enough to be able to handle a vehicle or vote or serve on a jury, something like that, we might petition the court to ask the person to retain their driving and voting. And the court's always happy to do that, but we do have to provide like medical evidence that the individual is able to drive or vote. A typical full guardianship does not include the authority for a guardian to consent to the ward being placed in an inpatient mental health treatment. So that would be like Banner Behavioral or Quail Run or Haven or any similar inpatient psychiatric treatment in a hospital setting. If, when we're doing the guardianship, if a family says, listen, there is a possibility, a likelihood within the next 12 months that this person may need inpatient mental health treatment, then we can add this on to the guardianship. But that means that we have to get a special health report and we have to specifically ask the court to add this on. It's not automatic. Okay. I'm going to talk about conservatorship types at the end. So when we're talking about guardianship, the very first most important step is who's going to serve as the guardian, right? We understand who the person who needs a guardian is, but who has priority to serve as the guardian? And so this is a list in order of who should serve as the guardian. So if there is already a guardian in place in another state, so jurisdiction means another state, then that same person will serve in Arizona. So here's what I mean by that. If you already have a guardianship in place when you lived in Colorado and then you moved to Arizona, If you've already been appointed as a guardian by the Colorado court, you're going to have priority to be appointed in Arizona. This usually may apply like if there's, you know, a discrepancy among the family or animosity among folks where you're like, okay, you know, so-and-so is the guardian there, but now they're moving to Arizona, so here's my chance. That's not your chance. If someone is the guardian in another state, they're very likely going to become appointed as the guardian in this state. If the person who needs the guardian, the incapacitated person, is competent to be able to give a preference of who they want, the court takes that into effect within reason, right? If they just nominate their best friend, that's not a good nomination, but you know, their preference among qualified people will be taken into account. If the person, the incapacitated person, has in the past, when they were competent, signed a power of attorney, then and they're nominated who would serve as their future guardian, that designation carries weight. So like if I sign a healthcare power of attorney today and I say, in the future, if I'm ever incapacitated, I want Karen to serve as my guardian, she would be delighted to do so, I know it. And that designation would carry weight. The court would likely honor my wishes. If the incapacitated person has a spouse, the spouse has priority. If they have adult children, the adult children then are next in line. Many of your children, so the incapacitated persons that we're discussing, like in this context, likely none of these above are going to apply, right? Likely the very first person with priority are going to be the parents, and the parents do have priority. Another kind of common situation would be like other relatives that take care of someone. So like if the parents are deceased or not in the picture and you're a grandparent and you take care of it, or it's your niece or nephew and you take care of the person and they live with you, that's fine too. So you can see that there's an order here that gets respected. I want to mention one thing, parents. In Arizona, if parents are divorced and they have joint custody, when the incapacitated child turns 18, this is not an opportunity for the parents to relitigate the custody agreement. If you had joint custody prior to the person turning age 18, you're going to be appointed as co-guardians at age 18. A lot of people don't like to hear that, but that is the law. It's mandatory. There's nothing I can do about it. So, all right. So when is guardianship necessary and when is it maybe not appropriate? This is a conversation I have with many clients. Guardianship is a very restrictive concept, right? So you're taking away someone's right to make decisions for themselves, taking away some of their autonomy and independence. It's a really big deal. It's an important decision. I meet with a lot of families that are like a little on the fence. You know, is this really necessary, especially for somebody who's really functional? It can make some families really uncomfortable, and I do understand that. We rely heavily on medical opinions. So like your child's doctor, perhaps the doctor who knows them best, may have some insight on their capability to, you know, have executive functioning and make important life decisions for themselves. Very likely, if you've been taking care of your child for 18 years, you know, they rely on you and your judgment. You got to think, like, remove yourself from the picture. Imagine if you weren't there to kind of help them and guide them through situations. This is an example that I give families a lot. Would your child be able to go to the doctor, talk about a medical issue, receive a prescription, fill the prescription, take the prescription? Can they do all those things? independently without assistance? If so, possibly it's worth a conversation if guardianship is maybe not appropriate, because, but you got to think, are they able to be in charge of their own healthcare decisions and kind of take instruction, understand consequences, side effects, things like that? You really want to make sure that you're focusing on their ability to like be safe out in the world. And if the conclusion becomes, maybe this person at this time wouldn't be able to independently do some of this, then guardianship may be the right choice. And this is an ever evolving conversation that I know families have amongst themselves. And, I'm always happy to kind of talk to families about some of this and, talk through it. Arizona will be, I believe, implementing a third option sometime soon, which is like we'll see how it plays out. I'm sure I'll do a presentation about it in, maybe next year or in the near future. It's basically like a supportive decision maker role. Let's call it like guardianship light. It's not something that is currently available to families at this moment, so we haven't seen it play out. And so here's my thoughts on that situation. If you've heard about this, as whenever it comes into play, I'm sure we'll hear feedback from families on how it actually works, like in real life, practically, like communicating with doctors and things like that. And we'll be able to see kind of the pros and cons of that. And so I don't want to weigh in too much more right now than that, but just know that, there's been a lot of advocacy in this area to have a more middle of the road option rather than guardianship and complete independence over here. And I really think that's valuable. So I'm in support of that middle option, being available to families. I think it's very appropriate. I just don't know how it's actually going to kind of work yet. All right, so this is the process for guardianship. This is what most of you want to know, is what is it, what happens, and, what are we, let me make sure I have time. Okay, I got plenty of time. So the first thing you do is you figure out, are you one of the people that I just mentioned who has priority to be guardian? If you are, then you file a petition. So there's no master registry of people in Arizona who need a guardian. The court is not going to send you a letter and say, hey, we heard your kid needs a guardian, do you want to be it? You have to approach the court. You have to file paperwork. Like, you have to take the initiative. If you believe someone needs a guardian beginning at age 18, the earliest you can file the paperwork is at age 17 and a half. And that allows plenty of time for the court process to take place, because it does take time, and for everything to be in place when your child turns age 18. Now, don't panic if our hearing date is after their 18th birthday, or if you guys, it's COVID this year and the whole world is bananas and you haven't gotten around to guardianship. It's okay. There are default laws in place. Like, if an emergency happened and your child is over the age of 18, and God forbid something happens to them, they get in a car accident, you're at the hospital, and someone's asking you for instruction, that's okay. There are emergency health decision, surrogate decision maker statutes in place where people who either don't have a guardian or don't have a healthcare power of attorney, they'll be able to, the hospital will be able to communicate with you and make decisions. So I want to say that there's no stress, no panic, it's okay. However, if you think guardianship is appropriate, you want to put this on your radar and, make your way towards doing this as soon as you can. So first thing you do, you file a petition. Earliest you can file is age 17 and a half. So the petition is a fancy word for a document that says all the pertinent information the court needs to know: your name, address, child's name, address, like their diagnoses, why they need a guardian. You have to file it with a doctor's report from their doctor. that should be from their MD. You know, my preference is not the nurse practitioner, just because the law says that it really should be from an RN or a doctor, which is a poorly worded statute because most nurse practitioners are actually not RNs. They're higher than RNs, but the law says RN or doctor. So I've been in court before with a health report from a nurse practitioner, and the judge is kind of not liked that. So try and get the doctor to write it. Notice. So, you know, one parent can't just file a petition in secret and not let everyone know. By law, everyone who's an interested person, so let's say that is the immediate family, your immediate family, anyone who's over age 18. So like the other parent, absolutely. I always include any adult siblings because I don't think it hurts. That usually covers the immediate family. There are, you know, in each case, when I meet with clients, I'll kind of get the lay of the land and figure out who are the family members in the picture. But everyone gets a copy of what you file. Everyone gets to know that you're seeking the guardianship, and they get to know when the hearing date is so that they can weigh in and object if they want to. All right, this process is, I mean, to be blunt, what we're doing is taking away rights for your child. You're taking away their right to make independent decisions. You're doing it because you believe it's in their best interest, but you are taking away their rights. So this is America. Whenever we take away someone's rights, they get their day in court and they get what's called due process under the law. And so part of making this a fair process for your child is that they get their own lawyer. So the court will appoint them their own lawyer. This lawyer will meet with your child. They will meet with your child. That cannot be avoided. Sometimes those are scheduled unannounced. Sometimes the court-appointed counsel, you know, the wrong way. Their job is to be the advocate and the mouthpiece for your child. So they're going to meet with your child. They're not going to be interested in your opinions. They're not going to invite you into the conversation. They really don't care about what you think. And so I just want to throw that out there. They're just trying to do their job. Cut them some slack. I'm going to leave it at that. The court is going to send out an investigator. Their job is to be the eyes and the ears of the judge and to write a report and give the judge facts about the situation. This visit really might be unannounced, although with COVID right now, honestly, everything is over the phone. And so their job is just to make sure that the person who's gonna have a guardian is in a safe situation and that this is what's best for them. Everyone will have a hearing at court. Usually these are in person. The court-appointed counsel has the ability to waive your child's appearance, so your child doesn't necessarily have to attend the hearing. All the hearings are by video right now during coronavirus, just so you know. And the commissioner, that's another word for the judge, they're going to review what you filed. They're going to, you know, make a determination if you should be guardian or not. They're going to review the medical report. They're going to ask the court-appointed counsel what they think, and they're going to make a decision. And if the decision is, yep, you seem like a good person to be guardian, guardianship seems necessary, we're going to appoint you, then this is what you're after. So this letters of appointment is a document, and that's the magic ticket that you want. So that's the document you take and you show the doctor, you show the school, you show anyone in the world who needs proof that you're the guardian. That's what you're after. And then every year you have to file an annual report of guardian with the court. So the court has a responsibility to make sure your child is doing okay and that the guardianship is in their best interest. So how the court keeps tabs on your child basically is that you have to file a report. If you don't file it, the court is going to send you letters, and eventually they're going to haul you back into court and ask why you didn't file your report. And no, don't let that happen. No one will be happy if that happens. So make sure you file your annual report. Okay, so when is a conservatorship necessary? For most of you guys, my suspicion is that your child, when they turn 18, if they are like most 18-year-olds, they probably don't really have any money, right? Most 18-year-olds don't. So a conservatorship is only necessary when the person who is incapacitated has money. So for most guardianships that I do where it's an 18-year-old, we're not doing a conservatorship because they don't have any of their own money. It's all the parents' money, or you know, they might be set to inherit from you later, but as of now, today, when we're doing the guardianship, they don't have any money. So if they do, that's another story, then we may have to do a conservatorship. So it's a very similar process, but you're appointed as a conservator to handle their funds, guardian to handle their healthcare decisions. I want to say this, for individuals who receive SSI or all tax, we're probably not going to do a conservatorship. We're probably going to have all of their funds be in a special needs trust. So this is what I want you to take away from this. If your child is going to come into their own money, so let's say grandparents passed away and you told them not to do this, but they did it anyways, they left your child a bunch of money just in their name, not in a trust or anything. You need to talk to an elder law attorney or a special needs planning attorney, and you need to explore the option of a first party special needs trust for your child. That would very likely be a better option than doing a conservatorship. Okay, so if you have any questions, I can take questions. And then I just added my email down here. So Karen generously offered 30 minutes of her time to any of you. I'm also happy to do that, but don't call my office directly because, you know, normally we charge to consult with clients on guardianship and conservatorship matters. So if you do want to talk to me, email me directly, remind me that you're a participant in this PowerPoint, and I would be glad to speak to you for a few minutes free. Whenever a lawyer speaks to someone, you know, I have to write a conflict check. So if I don't get back to you immediately, it's probably because I'm checking your name in our system to make sure I don't have a conflict. Okay, so I'm going to stop share.
Thank you, Megan.
Yeah.
That was awesome, as always. Appreciate that. Do we have any questions? You guys have been a quiet crowd today. No, does anybody have any questions? We have a few minutes left and we can take them if you'd like. While I'm waiting to see if anybody has any questions, I just also want to mention that this afternoon I'll be sending out a survey. So please take the 2 minutes to complete it because it helps Megan and I in the future understand how we're doing and if there's anything else we should present. We look forward to the feedback, and will also let us know if you want us to contact you in the future. So thank you for doing the survey. Thank you for attending this afternoon. And I don't see any questions. Oh,
I see someone
said that. We get a question. Adam, go ahead.
Hi, thank you for the presentation. I just a question, and I mean, I don't know how to word this, but past experiences that I've run into with families that, you know, determine there is a need, one for protecting their child, their special needs child, but also to form this trust and go through the, you know, the process. But a lot of times the hang up I get is, okay, they establish a need, but is it cost effective? Not cost effective. Is it in their wheelhouse to, because a lot of times they don't go through this process because they say, well, I can't afford it. So affordability is, I guess, the question about what are we looking at to kind of form a trust and kind of go through the process.
Okay, I am trying to pull up a link for you all for self-service forms. I always like to include this in all my presentations. Perfect. All right, so in the chat, can I do this?
Try.
I don't see the normal chat button like on most Zooms.
Yeah, because it's a webinar, it's not a meeting.
Bummer. All right, I'm gonna share my screen really quick.
Go ahead.
How do I do that?
On the bottom, share screen.
All right, so can you guys see this link up here?
Yes.
Copy this down. If you go to Maricopa County self-service forms for the probate court, so guardianship is through the probate court, then you can click on guardianship of an adult, and there's like all these instructions, and I'm not going to lie to you, this is a difficult process, but this is a tool that you can use to try it if you want to try it. You're doing guardianship of an adult because the guardianship is going to become effective at age 18. Even though your child might be a minor now, it's not a guardianship or a conservatorship of a minor child. It's of an adult. So do that one. Okay, so I'm going to stop share. I'm a really big believer in this, that I believe the courts should be accessible. This process in particular is so important. It should be accessible to everyone without a lawyer. Unfortunately, it's a lot of paperwork and a lot of people do get overwhelmed. I've been in court before where someone has, like a family is there without a lawyer and the judge is going to tell them, unfortunately, you didn't do the paperwork right, so you got to fix this and then come back. That's always frustrating to see, but, it is something that if you can't afford, but you think it's appropriate, I would encourage you to do the self-service forms and to try it. Our services for guardianship, we normally do guardianships on an hourly basis, and my estimate for the total fees, like for what I'll call a vanilla guardianship, that means no one's fighting, there's no weird issues, there's nothing crazy happening. Could be anywhere from $1,500 to $3,000. I can always give people like a more specific quote once I kind of get the situation. A couple reasons why I would encourage someone to use a lawyer. I mentioned if the parents are divorced, it's a good idea to go through a lawyer to do the guardianship. It adds a whole layer to it that's a little complicated. If there's going to be any conflict whatsoever, it's usually a good idea to use the services of an attorney if there's any strange issues. To set up a special needs trust that's a loaded question because there's many different types of special needs trusts, but that is an easy thing for me to answer after talking to someone and getting some facts. I can give you a very specific quote on what it would cost. It depends on what the family wants, where the money is coming from, the money that's going to be used to fund the trust. And so let me just break this down. Normally for questions about guardianship, I charge for my time. For this audience, we're not doing that, up to 30 minutes. Normally, we do not charge for questions regarding trusts. So anyone who wants information can call my office and schedule time to have a consultation with me for free. They can give me the information about their family, about the funds, about the trust, and they can information gather, I can information gather, and I can give them a very specific, quote on what it would cost to accomplish whatever their goals are. So does that help, Adam?
Yeah, no, thank you very much. It does, and it's kind of in line of what I've researched, attorneys here in Tucson. But that's good that, you know, you're available resource, and you work with Karen. I'm also with Mass Mutual, so I think that type of transition would be easy to work with. So yeah, thank you very much.
Sure.
And Adam, we can talk some more offline too.
Okay, sounds good. Thanks.
Anybody else have any additional questions before we sign off? Well, I greatly appreciate everybody's time. I hope you found this of value, and hope to see you on another webinar. I'm doing them regularly through the end of the year with different information. So take care of yourself and your families, and we'll talk soon. Bye now.